Hello, everyone. Can you all hear me?
Yes.
Excellent. I've just had some messages saying that my audio wasn't working, so I'm glad that's all, all in check. We're bang on 6 o'clock, so I might just give it a minute or so to see if there's any others planning on joining. Pardon me. Otherwise, we'll jump in. For those on the video or that are here now, just let me know if there's any disruptions or lag with the connection. I've just had a few problems today, so do just let me know. All right. Well, look, we've got a few people joining, but we're not jumping by any great mass, so let's just kick on. Thank you for joining tonight. I'm Arabella. It's lovely to meet you all finally. Apologies for the late cancellation last week, but we are going to be looking at weeks 1 and 2 in this session. We do technically have 2 hours for tonight, but I do appreciate that it is, a time when people are coming home from work, dealing with children and dinner. So we'll see how we go. I'm happy to move more quickly through certain aspects, but I'll leave that up to you guys tonight. I thought I'd just start out the session with some sort of subject housekeeping, I'll call it. We'll have a quick discussion around the assessments. Then we can jump into the tutorial work. I will obviously allow time for questions because I think that's really important. I'll start off by saying I'm hoping that everyone has had the opportunity to have a look at the what to expect in this subject video. If you haven't, please have a watch. It's not too long. The key takeaways from that are that in this subject, you will need to read some case law, and the notes that are provided to you are a starting point. I think most of you are in your 3rd year, roughly. So at this stage in the game, and if you go on to practice, you will need to be able to collate your own notes and learning materials. So I do really encourage you to do that. As we move through the material, you'll really see how reading the cases and seeing how the law is applied is extremely useful for your understanding. So if you haven't done that, please do. The other thing is in this subject, look, we look at succession law as a whole, but in practice, a lot of solicitors will look at certain aspects. So you might focus on estate planning, litigation, estate administration. So we scratch the surface in many respects, but what you will hopefully have after completing this subject is a good general understanding of the area of law, because it is quite practical and it does prop up in many areas of practice. Now, I will also say that I don't have the answers to everything, and I'm sure that a lot of you doing this subject may work in a legal firm yourself or have some experience in the area. So there may be different views and different ways of doing things, which is great. Pardon me. I always encourage discussion. But particularly when we do get to some later units, particularly around estate administration and family provision applications, there are many ways to skin a cat. So if you do have your own personal experiences, do bring that along if you're comfortable to the tutorials to share. If you do have questions, the tutorial space or workshop space is a great area to raise those questions, but obviously you can contact me separately. If you're wanting to do that, email is best. I have had some students reach out asking about a Teams chat. I believe there is a Teams chat. I'm having trouble accessing that. So if you have messaged me on Teams with questions, please email me and I'll try and get that up and running. Teams is another good forum, particularly for student interaction and a sounding board for ideas and questions that you might have. If there's anything that you're particularly struggling with, if there's feedback that you have, if you want me to focus on certain areas or provide you with certain forms of example, please let me know. Very open to constructive feedback. There is an opportunity to provide feedback at the end of the subject, but that doesn't help us as we're going along now. So if there is anything, please do reach out. If you really just don't like the subject, I'm sorry, I can't help you with that, but I will provide you with as much assistance as I can to get through it. So look, that's sort of the housekeeping that I wanted to run through. I'll pause now. Are there any questions relating to any of that people have for me at this stage? I'll take silence as a no.
I've got one question, if you don't mind.
Yes, sure.
Just in relation to the assessments, I know you haven't gone across any of that yet. When you ask for a legal advice letter, okay, in the past, in one instance, I've been marked down for putting in legislation and reference and all that sort of stuff. And then in another one, so I took it out because they say, oh, in a real advice letter, you don't do this. And then so the next time I had an advice letter to do, I left it out and I got marked down because I didn't put legislation and references and stuff. So do you want a real advice letter, or do you want one that shows that we actually know the subject, and like I would think you would like? But
so good segue into assessment. So this is obviously in relation to the practical assessment, the first assessment piece. The criteria rubric does refer to referencing your cases and your legislation. So as you've identified, Ian, in a letter of advice, a solicitor generally will not include, big paragraphs and, referencing and all of that. For this particular piece of assessment, we do want referencing. So we do want reference to legislation, case law, sections, all of that. So we do want you to clearly explain all of that. But I personally don't think you need to be putting massive chunks of sections in your letter. No. I think it's something that should be footnoted. So yes, for this, we do want footnotes. We do want you to refer to cases and legislation. So put that in. But in practice, you probably wouldn't. But we just need you to demonstrate that you know why you're saying what you're saying and giving that advice.
Great, thank you.
Cool. So with respect to that first written piece of assessment, the 40% practical, for those that haven't watched the little welcome video, that scenario, so that question will be released on Friday the 17th. Yes, Friday the 17th by 9 a.m. So on my calculation, that gives you about 5 weeks to prepare and submit your assessment. I am of the view that is sufficient time. And we purposely delayed releasing the question until a little bit later because the first 2 weeks really do provide that foundation that you need to sort of respond. So you've got the 5 weeks. It's due on the 22nd of December. Again, this date was chosen so that hopefully you can just enjoy your Christmas break and you don't have to worry about assessment. If you do need an extension though, and I should say this applies to the second piece of assessment as well, the sooner that you can contact me and arrange that, the better. Because there's nothing worse than getting an extension request at the last minute. it's very stressful for you, and it can be stressful and a little bit difficult for me to organise if it's particularly last minute. Having said that, completely understand that things happen, and that might be the case that you find yourself in. That's fine, but as much as possible, apply for the extension in advance. The other thing I just wanted to note was if you have an accessibility plan that impacts when you or how long you have to complete assessments, if you haven't already, please send that through to me and we can have a discussion about it. A number of you already have, so thank you. But if you haven't, just a reminder, please send that through. So there's the two pieces of assessment. I'll focus a little bit more on the second piece as we approach that. Does anyone have any questions specifically around the first piece of assessment or the format that you'd like me to run through at this point? Nope. Great. There might be some questions once it's released, but the format is set out in the subject plan that's available to you all. All right, so that's sort of our housekeeping done, covered assessments. I now just want to open the floor before we jump into our first workshop question set. Any questions about the week 1 material? Should say the week 1 and week 2 really are your foundations, I think, on which we will build. The nature and function of a will and the formal requirements and testamentary capacity. These come up again and again in various different arms of succession law. Testamentary capacity is a really, really important concept to understand. So, you know, if anyone's got any questions around that, happy to go through it. But I think everyone seems great.
I did have one question, and I don't know if I'm jumping ahead, but in the review questions for week 1, so not the tutorial, the review questions.
Yes.
In question 2, it was which of the following assets will not form estate property? And option A was a house owned by the deceased and his brother held as joint tenants. And in the answer, that was the answer, but I thought that I was a little unsure because the difference between obviously, the question was held as tenants in common. I thought it wouldn't form the estate if it was held as joint tenants, but as tenants in common, you do have the capacity to disperse it. So I was just a little bit unsure if that's a typo or if I have completely
off the top of my head, that sounds like a typo.
Yeah.
Yes.
I'm like,
so
I'll have completely misinterpret land law that I did like last semester?
No.
Or is that a typo?
No, look, I'll have a look. I don't have it in front of me, but look, jointly owned assets will pass to the surviving asset holder, so will not form part of the estate. If it is tenants in common, absolutely. The proportion that the deceased owns will form part of their estate. So thank you, Talia. I will have a look at the materials and see if we can get that updated. Beautiful. So any other questions? Because then we'll jump into our first tutorial. Let's bring up the questions. Yep. All right. So look, I think that this first tutorial, it's really just ensuring that you have a good understanding. So our first question is explain the function of a will and how a will differs to an enduring power of attorney. So does anyone feel comfortable jumping in and helping us out with that question?
Hey, Arabella. I'm happy to jump in.
Excellent. Thank you, Amy. Great.
Okay, so the way that I looked at it, so a will, it's a legal document which outlines how a person's assets and property should be distributed after their death. And that obviously wills can also cover matters such as appointing guardians for minors and include funeral arrangements. Whereas your enduring power of attorney, it is also a legal document, but it grants someone authority to make decisions such as like financial and legal decisions on behalf of a person, being the principal who actually creates that document. But it's typically used to manage a person's financial and legal affairs in the event they become incapacitated or unable to make decisions for themselves. That was, to me, the two big differences.
Wonderful. Excellent answer. Now, thank you, Amy. I heard someone else jumping in and I wasn't too sure who that was. So whoever that was.
That was me, Arabella, but I think Amy has explained it quite well.
No worries, Luke. Is there anything that you wanted to add to Amy's explanation?
No, thanks.
Yeah, I'm happy to.
And the authority for that is contained in, well, the enduring power of attorney is contained in the Power of Attorney Act 1998, Queensland, Section 32, subsection 1.
Excellent. Thanks, Bill.
I have something to add.
Excellent. Yes.
Yep. So the will becomes effective upon your death, while the enduring power of attorney is effective during your lifetime. Obviously, specifically when incapacitated, and the scope. So the scope, the will deals with the distribution of assets and appointment of guardians, as was discussed. So yeah.
Wonderful. Yep. Thanks, Kim. No, everyone's picked up on all of the key points that I wanted you to pick up on, so that's excellent. Namely, the will operates once someone's passed away, and the enduring power of attorney will operate during the lifetime. Power of attorney will also be automatically revoked on death. So in practice, you will sometimes see people saying, oh, I've got authority to deal with the deceased person's affairs. I'm their attorney. I've got the power of attorney. Unfortunately, that's not the case because it is revoked on death. And similarly, a will really doesn't have a great deal of power or authority when someone's still alive. Provided they've got capacity, they can amend it, change it whenever they want. Excellent. Any questions around functions of wills or powers of attorney?
No questions, but I was just going to say, as someone, I work in the area, and commonly I see people like powers of attorney get quite confused between the difference of a will and enduring power of attorney, and they actually think that an attorney is an executor, and you have to sit down and explain to them the common differences between the two. So it's actually very handy to have that understanding of the difference.
Yeah, absolutely, Ella. It's funny, isn't it? People are so confident. They think, oh no, I can do this. I'm the attorney. No, you need to be an executor. They've passed away. So yeah, absolutely. All right, so we'll move on to...
Sorry, Arabella, can I just ask?
Yes.
My understanding is that you can have and I don't know this is the right word.
That's okay.
But an active power of attorney. It's not necessarily called an active power of attorney. Like, so if someone is not necessarily incapacitated, but gives somebody the authority to make decisions on their behalf because they are deteriorating. And I only say that because my sister has one with her husband, but I don't know what it's called.
Okay, so what your sister might have, Julie, is she might have an enduring power of attorney, but with respect to her financial matters, she might have appointed her husband to make decisions on her behalf immediately. So he has that authority, to attend to, if she's quite poorly, she might not be able to sort of attend to her financial and legal affairs. So perhaps he's been appointed immediately, so he has that power, even though she still has her capacity. Possibly. I haven't heard of the term an active power of attorney, but it might be that. The other thing that could be in place, which I'm not sure the notes went into a great detail on, but is a general power of attorney, which usually only operates when someone still has capacity. So they're rarer.
Arabella,
Yes.
I am a supportive power of attorney for a disabled person. So she still makes her own decisions.
Yes.
But she comes to me, so I can talk to people on her behalf.
Yep.
I can talk to people like Centrelink, the bank,
yep,
all different sorts of people on her behalf to help her understand her situation. So is that maybe what we're talking about?
Possibly. I mean, when you look at the enduring power of attorney as a document, you are guided by the general principles, which is to always include the adult that's made the document, and sort of to take into account their wishes and affairs. So, I mean, I'd be interested to see, and I know obviously you can't show me, but I'd be interested to see the documentation that's used to create that, or if it is simply an appointment under an enduring power of attorney document, or an order of QCAT, perhaps in that case. But attorneys do often provide that support to the principal, particularly if they have been appointed immediately with respect to the financial matters, because you do need to get that input from the principal. So absolutely providing that support. And I guess the attorneys do still have that capacity to make decisions, even when the person or the principal has capacity, but just perhaps can't. So I haven't heard of the supportive specifically as a document, but I'm sure.
I'm in Victoria. I'm happy to redact it and share it with you. But
right.
Yeah, I'm in Victoria.
Okay.
So that might be a spin on things, but yeah,
right.
It actually literally says supportive power of attorney.
Okay, maybe that's a Victorian thing. So Renee, yeah, absolutely. If you have the time and the
I'll redact it and share it with you. Happy to.
Great, awesome.
Yeah, my sister's in Victoria as well. That's why listening to that, I think it might be a general one. I just wanted to make the point that you don't necessarily have to be
incapacitated.
Yeah, to have a power of attorney activated, I guess, was the point I was trying to make.
Yeah.
The reason why I was asked was because this person felt that she gets taken advantage of. So she wanted to be able to say, no, I need my supportive power of attorney here before I make that decision.
Right. Okay. Yep. No, that makes a lot of sense. Well, Renee, if you are happy to share that, that might be something of interest for the group. I'll definitely have a look at that myself with my colleagues in Victoria. So I might be able to come back with a bit more of a definitive answer for you all. Let's then jump on to question number 2. And look, this was a little bit of a trick question, I guess. When should a will and enduring power of attorney be prepared? What do people think?
I was guided by Form 9 that you provided.
Yes.
Which stated that an enduring power of attorney explanatory guide, at some point in the future, a situation may arise where you're unable to make your own decisions about these matters. This might be because of an accident, a medical condition, or a mental illness. An enduring power of attorney allows you to appoint people you trust to make decisions if you are unable to. And Section 41, subsection 1, the Power of Attorney Act states that a principal will have the capacity to make an enduring power of attorney only if the principal is capable of making an enduring power of attorney freely and voluntarily and understands the nature and effect of the enduring power of attorney. So that's what I had in my answer.
Yep. Great. So with respect to both a will and an enduring power of attorney, you need to have capacity to do so. So that's very important. Amy, I can see you've got your hand raised.
I kind of answered it and said, as a will, you should be prepared as soon as an individual reaches the age of 8 or 18 being that majority, and that they have assets or property that they're wanting to distribute and wishes after their death. And the EPOA, it's a bit of a funny one, but I think when an individual wants to start planning for that possibility of becoming incapacitated and unable to make their own financial and legal decisions. I know it's a bit of an odd one. I don't think you could really put a time frame or a time stand or anything on it, because I think it really is dependent upon what's happening in your life, your health, your things like that.
Yeah, absolutely. Great. Thanks, Amy. Reese?
Yeah, lot of what Amy said was what I had written down.
Yeah.
A will once you turn 18, but also life events, marriage,
Yes.
retirement, etc.
Yeah, wonderful. So with respect to wills, certainly those big life events usually are when people will consider their estate planning. If perhaps they've prepared a will earlier, it might be a time to review and update. But to the points that Amy and Reese have made, I completely agree. As soon as you're 18, people should be getting a will. This is my view, but I think it's also a very practical position to take. We'll cover this a little bit later on in the material, later weeks, but your will allows you to appoint an executor, which means there's someone that will be around to look after your affairs and finalise your estate. If you don't have a will, you don't have an executor appointed, and the process can be a lot harder. It can be a lot more costly for the people that are left behind, having to deal with your estate. So I'm not going to go into too much detail because we touch on that later on, but it does allow you, I guess, to pass that control and that authority on once you've passed. Ella, you've got your hand up.
Yeah, I was also going to say, like, if you have like a falling out with a family member that you've appointed as your executor, it's very important to make sure, like, if that doesn't reflect your wishes anymore, that you are making that change. Also, we always tell our clients, if you're, going overseas on a big holiday, just for precautionary or, surgery or, if an executor passes away, it's really important to review your estate planning.
Yeah, absolutely. No, they're very good points, and certainly very good times for people to review and even to put their estate planning in place in the first place. So no, absolutely agree. Ian?
There was just a really timely article by the Queensland Law Society this week about EPOAs, and that they were sort of saying that whenever anybody came to get a will, it should be, would you like an EPOA with that? Sort of like you're asking whether you want chips with your McDonald's. So, and they just said it was imperative to get that into the will for the client's benefit. So, yeah.
No, absolutely. And I guess as a practice point, as Ian has touched on, it really is your will and enduring power of attorney are things that you really should be looking at as part of your overall estate plan. And certainly that is generally the approach that most estate planning solicitors will take. Thanks for that, Ian. That's a very good point. Don't think, no more hands. All right, so let's move on to question 3. And I think we were already touching on these things a little bit, but what matters should a will maker consider when they're appointing an executor in their will? Oh, great. Renee's just popped into the chat that there's a screenshot of the document. So thank you, Renee. Amy.
I'm sorry that I'm talking so much, but I'm really excited to do 6 sessions.
No, that's okay.
I feel like a super nerd, and I apologize to everyone. But I think some of the things, and again, it's from places where I've worked and just other considerations, that trustworthiness, integrity, of a person you're appointing. Sometimes their organizational skills too. You kind of, I think it can come into play. What are they like with handling your financial assets? Like, what are they like handling their own monies, their availabilities, geographic locations, what's their communication skills, emotional resilience? Like, I don't think there's a one-stop shop list, is there?
No,
there's probably some other ones that I had thought about, and I guess willingness as well, because there's no point appointing the executor if they're not willing or able to act, kind of thing. Like obviously we'll talk about it. Like you mentioned, Arabella, executors later, but yeah, I mean, you wouldn't appoint someone who blatantly says, "I don't want to do it."
Absolutely, yeah, absolutely. That's a big one. And I guess to jump around a little bit, you also want to make sure that when you're appointing your attorneys, that the same qualities you sort of want in both an executor and an attorney. You want to make sure that your attorney is happy to undertake the role, because not only will they be looking after financial affairs potentially, they'll also be making your medical, personal decisions. So in some respects, acting as an attorney, some may consider it a harder job than an executor. But really good points, Amy. I agree with all of those. Does anyone else have anything that they want to contribute? Any other things that we need to consider? Julie.
In the textbook, it says recommends that you have more than one.
Yes.
More than one representative, but would that be an issue if there's deadlock as to what you want to do with it? Would you need a, would you need guidelines as to how you're going to deal with disagreements if you
I
both
guess
have different ideas?
This raises the question, Daryl, of if you've got two people that you don't think are going to get on, would you appoint them jointly as your executors? So you'd need to consider that. Just going back to your initial point, that it's always recommended to have more than one. Absolutely. We never know what's going to happen. An executor might simply not want to do it. They may have lost capacity. They may have died. Or there may be a conflict of interest. So that was something else that we need to be aware of when appointing an executor. Is there a conflict of interest there? Julie, you had your hand raised.
Yeah, I think I was also going to say it depends on the complexity of your estate.
Yes.
Because you could probably handle, I've been the executive before for my family.
Yep.
And it's all right if there isn't too much involved in terms of assets and stuff, but and definitely agree, because I've been a joint power of attorney and executor with my sister, is that you really do have to get on and be on the same page, because otherwise it becomes really, really challenging. And I was going to say you must be 18 years plus was the other thing.
That's right.
I was just going to say, adding on to what Julie said, you've got to be so careful with who you select as your executors, because we have a matter at the moment where we have two executors and they just do not get along, and it's literally like looking after children, because you're trying to be their parent and tell them to grow up and remind them of what their purpose is, except for getting bombarded with emails of he said, she said, and it's just very difficult. Yes,
no, my heart goes out to you, because I've been in that situation myself, and it is extremely difficult. And I've also been on the sort of the flip side, where I've had clients come to me and say, they're preparing their will. They've got two children, and they say, I don't want, my son to think that I'm favoring my daughter. I want them both to be involved. When in reality, they're really setting their children up for disaster if they don't get on and they can't work well together. Harry?
Yeah, I don't know, I might have missed it, but wouldn't the first step be if they're willing to do it?
Yes, no, I think someone did raise that, but absolutely, you need to make sure that your executor is willing to act in that role, because if not, if you don't have a backup, again, time and money will be wasted. So absolutely, we need to make sure that the person wants to do it. Now, I'm not sure, Kim or Belinda, who came first? Kim?
Belinda was first.
Oh, okay, Belinda, sorry.
Just a quick question, Arabella, just in relation to Amy's point about the willingness to act, particularly in relation to the enduring power of attorney.
Yes.
I was just wondering, we just had a personal instance arise recently where a family member decided that they could no longer wanted to act as an enduring power of attorney. So how does that work when they decide that they've changed their mind, they've decided that they can't make the right decisions for whoever they're acting for? How does that actually work?
The first sort of consideration will be whether or not the principal, whether they've lost capacity, or if they're still, they've got the capacity to make decisions themselves. If the principal has lost capacity, it's a much more difficult process, and ordinarily there needs to be an order that the attorney is removed or no longer acts. So that's a bit more of an involved process. If the principal still has capacity, the attorney can provide written notice to them. So it really just depends on sort of the stage that the attorney decides that they don't want to act in the role.
Great, thank you.
No worries. Kim?
Yeah, just a question in relation to how often is it, like if there's big families or you've got siblings and they don't get on, and you want to pick two, so you don't know which two, and the two that you pick, the others won't agree.
Yes.
How often is it that people will go and leave it with a lawyer or appoint? Can they actually sign a form to appoint a lawyer? So then when that happens, it's at the lawyer's office. And do they then obviously charge out of the will for their services at the end of it? Is that right?
No, it's a very good question. So absolutely. I can make a will and appoint a solicitor or an accountant or a trusted, financial advisor to be my executor. In much the same way that we need to make sure that an executor is willing, we need to make sure that the solicitor is willing, and also normally a firm will take a position as to whether or not their staff, their employed solicitors, can act as an executor. Because as an executor, you do have certain, duties and obligations in that role. So some solicitors absolutely will. So that is very common, and yes, you can do it. Can they charge? Ordinarily, they can charge to a degree. Yes, they can. Most solicitors will provide, if they offer the service of being appointed as an executor, they would usually provide sort of a schedule of fees so that the will maker sort of has a good understanding of what might be charged. Ella, you might have some thoughts on this as well. Every executor is entitled to executor's commission. So that's a payment for the pains and troubles. Jumping ahead a little bit, but every executor is entitled to that. If a solicitor charges for the work that they do in their capacity as a solicitor, ordinarily they won't seek a claim for commission. So I see Ella nodding, so I think we're similar wavelengths here. So yes, a solicitor can. They can charge. Normally they won't seek commission.
Yeah, we've got an estate file, and one of our directors, the executor, and she says, she's entitled to, but she won't. She hasn't charged commission in her whole, career as a solicitor.
Yeah. And look, sometimes to be on the safe side, and again, Ella, probably your firm does this as well, there'll be a specific clause in the will that says, my executor can charge as a solicitor for the professional services that they engage in, just so that there is no confusion.
The solicitor has to give written notice as well before the will's signed if they're appointed as executor.
Yep. Great. All right. So look, I think we've covered off really well on the matters to consider when appointing executors and attorneys. So let's move on then to question number 4. And I think we touched on this right at the start a little bit, but will all of a deceased person's assets form part of the estate? Explain why or why not. What are people's thoughts? Yep, Julie.
Only assets that a deceased person owns and controls can form part of the will.
Mm-hmm.
Owning an asset with another person in joint names the ownership passes directly to the surviving joint owner upon death of the first owner. This is called the right of survivorship.
Yes.
And then we go on to talk about joint owned property, super, life insurance,
yep,
trust assets, assets owned by a company, etc.
Yep. Beautiful. Amy?
Yeah, I would mimic what Julie's mentioned. So like what naturally is included is your real and personal properties, investments, vehicles, personal effects, things like that. But naturally, yeah, your assets held in joint tenancy because of that doctrine, it sits out. Superannuation funds, but only if there's not that binding benefit death nomination type form.
Binding death benefit nomination, yep.
Yeah, I found that one actually really interesting. That was something I did not know. The life insurance proceeds, again, unless I think that the policyholder and they also list themselves as a beneficiary.
Yes.
And like any assets that are held in trusts, family trust, discretionary trust, things like that, that they naturally are outside.
Yes, beautiful. So with respect to superannuation, just to highlight that, a binding death benefit nomination, for those that haven't come across it, it's basically a nomination form which allows you to nominate the beneficiary of your superannuation death benefits. However, there is a limited class of eligible beneficiary that can be nominated. So usually it's a spouse, a child, or your estate. And there's certain rules, or if you're in an interdependency relationship, and there's certain rules around how a person meets the criteria to fall into one of those categories. So for example, if you've got a husband and wife, they've got 2 kids, and the wife nominates her husband as a spouse to receive her superannuation death benefits. The death benefit will be paid directly to the husband's spouse, the husband, and it won't form part of the estate. So it completely bypasses the estate environment. Let's say, though, that the wife had nominated her sister, who was not financially dependent, didn't live with them, no real connection, but she just had a particularly close relationship with her sister and wanted her to benefit. Sisters generally do not form part of the accepted beneficiary class. So that would be an invalid nomination. So I don't expect you to have, an in-depth understanding of binding death benefit nominations and how they work, more just for interest. But what we do need to focus on is that superannuation isn't an estate asset unless it's specifically directed to the estate, and that is done by way of the binding death benefit nomination. Ian, you've got a question?
It was just something that Talitha was touching on in the other questions while we were on this part of the subject. I was looking for it through the notes on page 11. Under the estate property of what's not included, it says jointly held assets. So that's why that house, I actually ticked that off as the right answer, but whether it's right or not, I don't know.
So if an asset is jointly held, so if a house is jointly held, it won't form part of the estate. That's right.
Okay, so the question that Talitha was asking about in the multiple choice ones, where it said the bloke and the brother own the house as tenants in common, that wouldn't be included then in the estate, would it? Yeah.
Oh, sorry, Ian. I think that there's a typo in the review question, so I'll have to go back and just double check exactly what's in the review questions. I don't have them open right now, but if an asset's held jointly, it won't form part of the estate. If the brothers held tenant in common shares, so 50% each, one brother died, his 50% share would form part of his estate. It wouldn't pass to the surviving brother.
Okay.
Yep.
So
but
what would be an example of a jointly held asset then, like they own a car or something together?
Yeah, so an example of a jointly held asset may be a property that's held as joint tenants or a jointly held bank account. So all of those assets would simply pass to the surviving joint tenant and wouldn't form part of the estate.
Okay, thank you.
No worries. And I will just say I'll double check the review questions and make sure that that's updated and confirm the correct answer for everyone. Excellent. All right. So yes, we've gone through quite an extensive list of the assets that won't form part of the estate, so that's good. Now, for question 5, I was going to show you some example wills where the identifying features have been redacted. So with right, and we can just go through and I can highlight the different clauses within the will. So the 2 documents that I've got, one of them is a will that was prepared by the public trustee, I believe, and then the second will is a copy of a will that was prepared by a private firm. I think there has been some amendments. I think we've got the will of Victoria Beckham to look at, but let me just share my screen for the first will. Bear with me. Okay, so just a thumbs up or a nod. Oh no, I don't think you can see that yet. Can everyone see a will on their screen? Yes, I've got some nods. Excellent. All right. So the question asks us to identify the revocation clause, the appointment of executor, specific gifts, and a residuary clause. So looking at this will, this is a fairly standard form will that the public trustee uses. I'm not exactly sure when this was done. Oh, yes, I am. 2014. So there might have been some changes to this precedent in the meantime, but this is the general look. So up here, clause 1, they refer to the cancellation of previous wills, but this is their revocation clause. So we're clearly saying I cancel my earlier wills. We move on at clause 2 to the appointment of executor. So in this case, the will maker has appointed the public trustee to be the executor of the will. Now, these wills also make a specific declaration that any beneficiary of the estate must survive by 30 days. So this is also reflected in the Succession Act. But again, sometimes it is much easier for directions to be provided in the body of a will rather than having to rely on legislation. Then we move on to, and I know this isn't in the question, but just for your own knowledge, then we move on to the powers. So quite often a will contain certain powers that the executor and trustee has. Again, the executor and trustee will have the same powers as contained in the trust legislation, but again, it's much easier for it to be clearly stated within the body of the will. So I should just say the powers clause will vary between precedents. So you might have done a will yourself and there might be quite extensive powers listed, or you might have done a will where it's quite a short recital, and that's okay. So at clause 5 then, we've got the guardianship appointment, and I'm sorry to say that I think this has been redacted a little bit hastily, but I appoint my father X and my mother Y of Queensland to be guardian of my daughter. So it's quite simple language that is used in these precedents, but it's very clear what the will maker is intending. Then we move on to clause 6, and this is the residuary clause. So what you've probably noticed in this will is that there is no specific gift clauses. So this will maker has decided that they simply want the balance of their estate to go to their mother and father. And so the disposal of my estate is the residuary clause. Clause 7, we've got the substitutional provisions, which basically just says if clause 6 can't take effect, and this would be in circumstances where both the father and the mother have failed to inherit. So let's say they've both died, for example. The substitutional provision is given at clause 8, where this will maker has gifted the whole of her estate or their estate to their sister. Absolutely. So this is sort of the backup provision if both parents have passed away. Now, interestingly, in this will, they've included a clause stating that can everyone still hear and see me? Yep, hopefully. They've included a provision stating that they're not making provision for their daughter because at this time I do not have custody. This is really interesting and something that we will touch on a little bit later down the track. Including these sorts of statements doesn't necessarily mean that, in this case, the daughter can't challenge the will. So a lot of people do include them, and there's mixed thinking around whether or not it is a good idea or a bad idea to do so. So jumping ahead a little bit to the week 2 material where we're looking at a valid execution. Let's just pretend that that's been signed. So the will maker has signed the will in the presence of 2 witnesses on the 8th of July 2014. And you'll see that it's also been signed on every page. So I know that you've just seen this, but any questions or comments around the provisions in this will? Anything you want me to explain in a bit more detail?
I guess it's quite vague. Like, it doesn't really specify what makes up the person's estate. Like, won't that be quite difficult for the executors to actually action?
Is that you, Grace?
Yeah, sorry.
Yes. No, that's okay. It's a very good question, but normally a will won't actually specify the person's assets unless they are making specific gifts. So what this will instead does is it says, I give everything that's in my estate to my parents. So what normally happens as part of the estate planning process, so when this person prepared this will, they would have sat down with, their solicitor or the public trustee officer and made a list and gone through and reviewed all of the assets that would form part of their estate. And it's at that stage that a solicitor can identify, okay, we need to specifically refer to this asset in the will, or, oh, this is a jointly owned asset, it's not going to form part of the estate. So it's actually quite common not to include and list all of your assets, but I do agree that it is quite a short and brief document. Any other questions or comments? What do people think? It is quite short, but does it do what it needs to, do we think?
We usually, sorry. I was just going to say, when in our initial appointments with our clients, we'll do like a will like that in the first instance, and then once taking their instructions, after the appointment, then we'll draft the more lengthy type of one, just in case if anything were to happen in the meantime, that they were covered with a basic form of will.
Yeah. So what Ella's referring to is solicitors have a duty to take instructions and prepare a will sort of as quickly as possible, in a very, as timely as possible. So if, for example, a person has quite complex affairs, or we need further instructions to ensure that the will fully meets its requirements, we might do what's called a stopgap or an interim will, which, as Ella said, it's often quite simple, and it really just covers the will maker for the time between providing those initial instructions and then being provided with the finalized detailed draft that fully addresses their estate planning needs. It can also be used, an interim will can sometimes be used to, if someone is at the drop of a hat having to travel in unexpected circumstances. But I know that most solicitors will always say to their clients, this isn't an interim document, it must be reviewed, and you must finish your proper estate planning process, because often the interim will doesn't go into the detail that it needs to. So, no, thanks for raising that, Ella. That's a very good point. Ian.
Just a question in relation to the way he's cut out an immediate family member being his daughter.
Yes.
Is that paragraph sufficient to do that? There's some myth that I've heard that to cut someone out so that they can't contest the will, you should leave them something. Is that true, or is that codswallop?
I'll say it's codswallop, but I'll caveat also by saying it sort of depends what you leave them. So in my view, including this statement really has no effect. This daughter has standing to make a claim, and we'll go into this in a lot of detail when we look at family provision applications, but for today's purposes, she's a daughter. She has standing to challenge a will, and whether or not this person includes a statement saying, I've left you out, doesn't stop her from making a claim. Similarly, and look, we've all heard it too, leave them $1. They can't challenge the will. They absolutely can challenge the will. If though, for example, you left them a reasonable gift, say $20,000, $50,000, really depends on your circumstances. It can sometimes make it harder for it to be commercially viable for the person to challenge the will, but it certainly doesn't extinguish that right at law to provide you notice and to bring the claim. So we'll go into it in a little bit more detail, but just for tonight, it certainly isn't going to stop the daughter from bringing a claim.
If that's the case, then as a solicitor, wouldn't you suggest to them that they wouldn't need to put that paragraph in because it's not going to make any difference anyway, or you just put it in what they want?
This is what solicitors will have differing views on. I'm happy to say I have the view that I don't put these sorts of statements in wills. My position is if it's admitted to probate, it becomes a public document. If you want to exclude someone, you can do what's called a statement of wishes, which you can sort of set out why you're excluding someone. Again, doesn't always carry a lot of weight. Some solicitors will have a completely different view and will regularly put these in. So there's some different schools of thought, but I don't.
Okay. Yeah. So that statement would just become an annexure to the will, or is that how it works?
A statement of wishes. Yeah. So like if you do a statement of wishes, you might include, sometimes people will include a paragraph that says, I've prepared a statement of wishes, for my executive's consideration, something like that. But it's not an annexure. So for example, if your will is admitted to probate, the statement of wishes wouldn't go with it. Rather, it's really just for your executors, to guide your executors.
Okay. Well, yeah, I didn't think it holds much water with anything, so that's good.
Yeah.
Okay. Yeah. Thank you.
Excellent. All right. So we do have a second will, but I'm also conscious of time. So general consensus, shall we move on to week 2, or would you like me to pull up the second will? Anyone?
Yeah,
Hand-
week two for me.
Someone said week 2. Yep, some nods. All right, no worries. So I'll stop sharing. Beautiful. All right. So wrapping up then week 1. Any other questions? Anything else, or do we feel, people on the call, that we are comfortable with what a will is, its function, what a power of attorney is, or enduring power of attorney is, and its function? Happy with all of that?
Can I just ask a question, Arabella? So
yes.
If you're getting 2 people to sign it, you say, for example, you've got another person that lives interstate. So say I was doing my will, I've got, I want to get 2, well, even for enduring power of attorney or whatever, and you want the person interstate to actually sign it, you can just post it. You can sign your part and then send it, can't you?
For a will, no. For an enduring power of attorney, yes.
Okay, right. But for a will, you need 2 people to do it there and then, witness it, and you do it. Okay. No, that's all good. I just wanted to double check that.
No, absolutely. It's a good question.
With the will that we're doing for our assessment part,
yes.
There's no set type of will. We can just do a will, like, as long as we follow the guidelines of how it needs to be set out.
Yes.
Something like that's still fine, like that example you just showed, isn't it?
Look, absolutely. And I should just pause and say, with this assessment, that's a very, very good question. In the assessment task sheet, you'll see that the will and the enduring power of attorney is only, I think, 10%. So I'm not expecting you to draft a perfectly wonderful U-Butte will that a solicitor would pull out. What I want you to do is identify, the key clauses that you need to include, look at the client instructions, and produce something that reflects that. Same with the enduring power of attorney, and the form is there. So if you produce something like this, absolutely fine. Absolutely fine. The focus is on the advice and being able to explain why you've done what you've done, what's important, and if there's further information that you need to give advice, to identify that. Cool. Excellent. All right. Well, let's jump into our second set of questions. So now we're looking at the formal requirements of a will and testamentary capacity. Very sorry, I should have asked, do people want a 5-minute break to go to the bathroom, grab a drink, or are we happy to power through? Sorry, I should have asked this at the start. Am I taking silence as happy to power through? Yes. All right. Thank you, Angela. I see you nodding.
Angela, I was just letting you know that people are actually putting things in the chat. We're not ignoring you. We're writing things down.
Oh, sorry. Look, this is my ignorance of Teams, isn't it? Sorry, everyone. Let me have a quick look. Yes, power through. Wonderful.
Wanted to just bring up something before when we were looking at the public trustee, and I think it was Grace that mentioned, like, it was a very basic will and there was no property or anything mentioned. It's probably important to bring up about the fact you need to probably be cautious if you are going to nominate specific property in a will, and what happens if that property is disposed of prior to your death, and how is that handled?
Yes. No. Very good point, Angela. Jumping ahead a little bit to our construction week, but no, that's a very, very good point. We'll touch on it, but if you are specifically gifting property in your will, you need to consider what happens if that property isn't around when you pass away, which means you need to consider how that property is described in the will. Otherwise, it may give rise to the concept of redemption. So we'll park that. It's very good. We can come back to this tutorial, or you can rewatch it when we get to that week. I think it's week, I want to say 5, but I'm not sure, when we look at the construction of a will. But there's definitely pros and cons for listing assets in your will. Thank you, Angela. And thank you for pointing out that there is Comments in the chat. So we're powering through. Thank you, everyone. I've got that open now, so I'll pay more attention to that. All right, week 2. Again, I can't stress that the understanding of what testamentary capacity is so important. So starting then with our first question, in your own words, what are the formal execution requirements of a valid will? So who wants to help us with this first question? Amy? Yep.
I'll be your serial pest again.
Oh, please, it's fine.
So obviously going through everything, obviously capacity, that you need to know that the testator has that capacity to understand the nature and then the effect of the will, and understands the extent to the assets, that the will's in writing. So whether it's handwritten, typed or printed.
Yes.
There needs to be the signature element of it, obviously, and, you know, signing in front of like the witnesses and all of that side of things. Obviously, I don't know.
Yeah.
Sorry.
Which section are we looking at in the Succession Act for our
10?
10.
Yes.
Yeah.
Perfect.
Section 10. Yeah.
Yep.
And something else that like I don't know if it's like a formal requirement, but I think you can say like it's best practice is to have those revocation clause. And I know previously a lot of people used to have like your attestation clauses, but I don't think that's really, I don't know if it's much of a thing that people tend to do.
Look, most precedents will have attestation clause. It's not a requirement.
Yeah, it's not a formal requirement. I think it's more of like best practice, same as like your revocation things. But essentially, yeah, your capacity in writing, the signature and your witnesses, I think they're your main ones, being that section 10 of the Succession Act.
Perfect. And Bill, I have a feeling that you will be able to answer this. Which section defines writing?
The Acts Interpretation Act.
Perfect. We've got section 32. So that's just something to keep in the back of your mind. Writing isn't just necessarily pen on paper. So just something to keep in the back of your mind, as well as the fact that a person making a mark is considered a form of signature. So it satisfies that writing requirement.
Wasn't it the estate of Slavinsky where a will was written on the deceased wall of their home and it was considered writing? Yeah.
Yep. No, look,
Weird.
yeah. There's some really weird and wonderful cases out there that do provide some good examples. So again, I encourage you to do some research and to have a look into these. But absolutely, sorry, I'm talking over someone.
We had a case where we acted for an executor where it was a suicide, and the deceased wrote like suicide notes, but then wrote on there basically like I want you to have my super, blah blah blah, and it ended up that the court accepted it as writing because he was, you know what I mean, like that was the deceased wishes, but it was like a suicide note.
Yeah, no, and look, there's actually quite a few examples, particularly in the informal will context, where suicide notes have been admitted as informal wills. What's particularly important, though, is section 10, subsection 7, is that the testator must intend to execute their will. So there must be that element of intention. So I could just willy-nilly sign a will as a joke. I'm not intending this to be my last will and testament. So that's something that's really key as well. We need to make sure that intention is present. So quick question. Does the testator actually need to physically sign the will themselves?
No.
What are you relying on there, Bill?
Section 2I, someone else in the presence of, or at the direction of the testator.
Yeah, excellent. So I can direct someone to sign on my behalf, and this may be in circumstances where, probably most obviously, where someone is quite frail, and they cannot physically sign themselves. So it can be useful. Now, can anyone act as a witness to the will?
No, not anyone. I mean,
No beneficiaries.
Yeah, you can't be a beneficiary. Or yeah, someone named in the will. Yeah,
yes.
Or a family member. Family member. Yeah.
And over the age of 18.
Yes. Perfect. Excellent. So we need to make sure that you've got a witness over the age of 18 and that they're not an interested party. Great. Anyone got any questions around execution requirements or anything further to add to this first question?
There was a Queensland case about a will being on a mobile phone.
Yes.
That I had an assignment on a few years back.
Yes. The name is escaping me right now, but there's a number of mobile phone cases where absolutely a text, paragraph saved in notes or an unsent text message, all of that can be admitted as usually an informal will. So yes, very weird and wonderful cases. I think I may have put the text message and suicide notes in the informal wills week's readings or reference readings. So if you are interested and you want to jump ahead, have a look there. Let's move on, just conscious of time a little bit, to question 2. Now, what is the difference between legal capacity and testamentary capacity? So what elements must be proved and what evidence might you rely on to support a finding of testamentary capacity? So a little bit involved in this question, but who wants to start us off?
Isn't legal capacity term referring to ability to exercise the decision-making process, where an adult has capacity to make certain decisions and they are able to understand and retain the information relating to the decision, the main choices available, understanding and weigh up the consequences of those choices, communicate the decision, and make a decision freely and voluntarily.
Excellent. So Bill's given us a really good definition of legal capacity. So then and actually, before we move on, just note, capacity will be defined in various pieces of legislation. So depending on your area of law and the legislation that you're dealing with, it may actually contain a different definition of capacity relevant to that legislation. So just a bit more broadly, we've got testamentary capacity, then we've got the capacity required to prepare an enduring power of attorney. In the personal injury space, there's a number of different acts that all refer to capacity and provide different definitions. So capacity is something that you could almost run an entire subject or several units on. So just keep that in mind. So specifically for our purposes, we're really focusing on testamentary capacity. So who wants to kick us off with testamentary capacity? Why is this so important? What is it?
Banks and Goodfellow says a will maker must, first of all, understand the nature and effect of a will, understand the assets he or she will be disposing of in his or her will, consider who might have a claim on his or her estate and who should be provided for, and not be suffering from a delusion of the mind.
Absolutely. So Banks and Goodfellow is our test, our age-old test for testamentary capacity. And testamentary capacity is unique to the making of a will. So the test that the elements that Ella just ran us through are specific to the preparation of a will. So what that means, and I'm sure you've covered this in your readings, is that a person may not have legal capacity, but they may actually have capacity to make a will. So that's something to really focus on and remember. Now, the other key case is that of Symes and Green and the rebuttable presumption that a duly executed will which is rational on its face, is that of a competent will maker. So looking at the will that we had on screen before, it's in writing, signed by the testator, signed by the two witnesses, rational on its face. We can presume that that will maker had capacity, unless we're provided with evidence that can rebut that. Then the onus shifts. People happy with that concept? Excellent. All right. Any questions around Banks and Goodfellow or the test, or any comments?
Arabella, could you just, what was it, Symes and Green?
Yes, Symes and Green.
And that one was for the test for?
That establishes the rebuttable presumption that a duly executed will, rational on its face, is that of a competent testator, so someone that has testamentary capacity.
Okay, thank you.
Sorry. So in terms of evidence then, what might you look for? So we've got Symes and Green rebuttable presumption. So we've got the valid will or the duly executed will. What might you look for?
Is it to look for the mental acuity?
Yes. So we want to make sure that the person isn't suffering sort of any illnesses that's going to impact on their capacity. So we might look for medical records or doctors, a referral from their referral notes from their doctor. What else might we look for?
I think also some of the notes, that like this, the solicitor can take as to when they're taking instructions as well. Just, can be utilised.
Absolutely. Yep.
Yeah, solicitors file notes.
Yes.
About their general disposition and the awareness of their assets.
Absolutely. Yep.
And the
absolutely.
Consequences of making a will.
Yep. Great.
Can I just ask, Arabella, when you've got someone in your office, and I know you talked about it a little bit in your tutorials that you did, but the online recordings, but say you have someone come in and you're going to start doing a will with them and you don't believe that they've got testamentary capacity, maybe they've come in on their own. How do you tend to handle something like that if you're really, aware that things aren't going to be able to progress?
Yeah. Look, normally to sort of ease people in, and look, I will just say this is just my personal take on things. I ease them in by trying to ask sort of open-ended questions to see if they can explain to me, firstly, why they're here, what they're wanting to do, just to see if there's sort of any general understanding of maybe what's going on or what might need to happen. If they can't do that, or the messaging that I'm receiving is quite confused or fragmented and just not clear, I usually take the approach of saying to them, we are doing your will. We want to make sure that it's correct and valid. And for me to do that, I need you to go and get a medical report or some, an assessment by your doctor so that we can confirm that you have capacity and nothing's going to impact on your ability to make your will. It can be a very difficult conversation to have. And it is something that a lot of lawyers, well, maybe not a lot, but some lawyers struggle with starting out, because you're sort of saying to the client, I'm not taking instructions today, I've got some concerns, and you're questioning their capacity. That can be quite insulting for a client that maybe hasn't realized that, their faculties are going, it can happen. But my general approach is to try and make them aware that they need to take these steps so that the work that I do is actually going to assist them, and it's not going to be subject to attack or simply fail when it ends up before a court. That's sort of my general approach, Emma, if that answers your question.
Yeah, that's really good. Just because, it's a fragile sort of topic, and they're often vulnerable, and they've gone to a lot of effort to get there for the appointment, and
yes,
then you sort of sending them on their merry way, and
yeah. And look, I think, and that's why I do try and have, even if it is just a general conversation with them, so that I can get a little bit of background or understanding for myself, so that it doesn't feel like a completely wasted appointment. Because yeah, I understand that it is quite often quite a big hurdle to get to a solicitor's office, for example. So yeah, you do what you can, but at the end of the day, as a solicitor, you need to make sure that you're, I guess, doing the best thing by your client, but also making sure that you're acting ethically as a solicitor. Now, Kim's just popped in the chat that Ryan and Dalton is a really good case. So yeah, look, if you haven't read Ryan and Dalton, I do encourage you to do that. It's quite modern. So, you know, it's a very good, clear example. So thanks, Kim. Definitely have a look at that one if you haven't already. The other things, just with respect to what evidence you might look at, or things that you might sort of further delve into. I sometimes look at when the will was prepared. Timings can be quite interesting and important, and also where. So, you know, for example, if you know, the will maker has consistently gone to a specific solicitor, and then goes to the public trustee a month before they pass, that might give off a few red flags as to, is there an issue with capacity? Why was this done? Was she unwell? What was she suffering from, etc.? They, not she. Any other questions around that? Read Wright and Dalton. If you haven't, that will help with your understanding. And look, I think capacity is a really good example of where looking at cases, looking at recent cases, sort of in any jurisdiction really, but Queensland, Victoria, New South Wales, they're quite useful for us, will help with your understanding, because courts refer to Banks and Goodfellow over and over again and apply the facts to the law. All right, now moving on to question 3. Julie, yep, cool, great. What role does medical evidence play in determining testamentary capacity?
My answer, I wrote just a little bit. I said, although not definitive in determining whether or not someone has a requisite capacity to prepare a will, obtaining medical evidence in the form of a medical report is prudent for solicitors to obtain on behalf of their client in order to address any potential question of the testator's capacity at the time of taking instructions and executing the will. It is a preventative measure against any concerns and claims on the will after the testator's death.
Yes. So getting medical evidence can really assist a solicitor throughout the estate planning process if there is sort of questions around capacity. What it really impacts is the medical evidence will assist you in determining whether or not the will maker could competently answer the 4 limbs in Banks and Goodfellow, and particularly the 4th limb. But again, it isn't definitive, and a person may medically be said to not have legal capacity, but you've probably seen in your readings, if there's a lucid period, for example, where they can provide very clear instructions, they know who they want to get what. That makes sense. You know what I mean? They know who they want to make gifts to. They know where their assets should be going. They know what they've got. They know who they should be providing for. And their illness isn't impacting on that decision-making ability. Arguably, they could make a will. So medical evidence is relevant, but it doesn't take away from the importance of really looking at the 4 limbs in Banks and Goodfellow. Great. All right, so we're at 7:25, which is great. And question 4 is all about looking at cases that have dealt with testamentary capacity. Now, I just jumped on Jade Barnett and found the most recent case, which is Ree Briggs, which I think probably a few of you might have seen as well. So I'm happy to run through Ree Briggs and just give a brief overview of what that case was about. But does anyone else, or did anyone have the time to find some cases that they want to share with the group, and we can pop it in the chat and have a little bit of a list of cases to read? Julie, you...
Yep, go for it.
Sorry, I was just going to say, Julie, you've popped in Roche and Roche. Do you want to run us through that one?
Yeah, so this is a South Australian case, and it was about testator was John Roach, the father, and there was a question about his capacity due to dementia. He had 3 daughters. He'd left pretty much most of his will to 2 of his daughters, and one of his daughters challenged the will, and she wanted to revoke a grant of probate which was already given in relation to John's will. And basically, I mean, it was 148 pages, but basically what happened was they determined that the evidence showed that John had comprehension sufficient to have testimony capacity. The application for revocation of the probate was dismissed. And there was a grant of probate from the last will. So she basically wanted to prove that the previous will should be the last will, not the more recent will.
Yes.
Because of that. So I found it interesting because he had less than optimum mental capacity caused by dementia, but it didn't impede his capacity to the extent and disposition of the estate.
Yeah.
So that's a really short summary of it. So I found it interesting because of the dementia factor.
Yep. No, that's a great example, Julie. Do you recall, so you said that one of the daughters was wanting to revoke the grant of probate and sought to propound the earlier will. Do you recall what evidence she was relying on? Was it that he had dementia at the time the last will was done?
He was in the early stages of dementia. And even though at no point, because this estate was worth $53 million, even at, and it was a family business, and even all of her dealings, so she had a falling out with him about, she made these demands about what she wanted, and the father said no, and she kept pushing for what she wanted. She had a falling out, and at no point during that whole discussion over a period of months did she raise anything to do with his early dementia or behaviour, but she was just using that diagnosis as a way of trying to revert back to the original will.
Yeah. Great, Julie. That's a really good example and a really good summary. Thank you for that. Does anyone else have a case that they'd like to share? No, that's all right. Oh, Bill, Rowe and Sudholtz. Do you want to talk us through that one?
It was actually very similar facts to the one that Julie just mentioned about the court had to determine. I wrote quite a few notes on it. Basically, Norman Alfred Hotter's, before he died, he made a third will, wherein he increased the amount he wanted to gift to a friend in his will several months before he died. At the time, he was in cognitive decline and despite the file notes and observations of the solicitor being of no probative value towards the mental state of Norm regarding why he wanted to change his will and his reasons for increasing his original gift from $500,000 to $1.5 million to a particular beneficiary, Norm suffered from a whole range of conditions, heart, renal conditions, a chronic obstructive pulmonary disease, all sorts of things that eventually brought about the onset of dementia. He appointed his neighbours, Justin and Vicky, who were his neighbours and helpers with bookkeeping and the rental of his commercial sheds. And they had an enduring power of attorney at the time for all his financial and personal matters and health matters also. He did a will in February 2016, where he appointed them as his executors and gave the whole of his estate to them, which was valued about $7 million. Due to his health decline, he had to eventually go into a nursing home. And Justin and Vicky, the executors, went on holidays, and Norm, who was in the nursing home at that time, he got a bit upset and agitated for some reason, and decided to make new provisions in a new will about leaving $500,000 to a long-time friend of his. This will was executed in February 2016. Then in November 2017, the solicitor was asked to return and draft a new will, and at that time, amongst other provisions, he wanted to gift this long-term person $1.5 million. When, at the time of his death in early 2018, that last will that he drafted was challenged by the executors. And I wrote some passages, I read the case and I wrote some passages about what the judge found, and also the observations and remarks he made in relation to the solicitor who was drafting the will, and on what type of file notes, the quality of the file notes, the probative value of them, and how they lacked any detail about whether that was any help to the judge about whether he had testamentary capacity for that final will. So ultimately, the judge said that Norm's memory impairment and compromised capacity for decision-making, together with contemporaneous evidence of his physical and mental state in November 2017, which was the third and final will, leads me to conclude that there is insufficient evidence to be satisfied that he was able to evaluate and discriminate between the respective strengths of the claims upon his testamentary bounty at that time. The evidence strongly suggests that his mental faculties had been so affected as to make him unequal to the task of making a will, even a relatively simple will of the kind which he made. Although I do not make a finding that he clearly lacked testamentary capacity in November 2017, I am not affirmatively satisfied that he did. Therefore, Kathy has not discharged, she was a long-term friend, not discharged the onus upon her, and I should declare against the force and validity of that third and final will. So it was the second will that was the valid one, and she ended up only receiving the $500,000. So Norm didn't meet the testamentary capacity in that final will, because by that stage, there was an onset of dementia. He kept forgetting what assets he had. He forgot things like when he wound up his superannuation self-managed fund. There was a whole range of issues with his cognitive decline and his mental capacity during that time. The judge made some remarks about, in one, I think it was paragraph 145, where he made some remarks about an experienced solicitor or solicitor's secretary. And I think you mentioned this, gets used to dealing with people making wills and are usually attuned to the red lights that flash when a person who is of suspect capacity comes across their paths.
Yes.
This is a case in which there were red lights flashing, or to use Mr. Wilson's words, alarm bells were ringing. The difficulty is that with those alarm bells ringing, Mr. Wilson did not ask, Mr. Wilson was a solicitor at the time, did not ask Norm questions about how much he had left Kathy in his previous will, the reasons for doing so at the time, and his reasons for substantially increasing the amount. He did not seek input of any treating doctor or get expert medical assessment of testamentary capacity at the time of making that third will.
Yes. So I think, Bill, this case really highlights a solicitor's duty to make those inquiries. And it also really highlights the need to ensure that you take very good file notes and that you ask questions to ensure that you are satisfied that each of the 4 limbs is satisfied. So probably a good case to have a look at in terms of a practical approach that solicitors should take, in addition to the exploration of the test for testamentary capacity. So thanks, Bill. That was a really good and really detailed summary. Thank you. Ian, I can see that you've got your hand raised. Have you got a question or a case that you'd like to share with us?
I nearly forgot what I was going to say. Just once again, the Queensland Law Society is running courses for succession advocates, and they're talking about linking the importance of linking human rights to succession law at the moment with elder abuse and undue influence. So it's just there's going to be probably more cases coming out, but they've recognised that human rights is a very important thing in relation to succession also. Yeah.
Yep, absolutely. Okay, so I've had 2 really good cases, Roche and Rowe. Any other cases that people want to share, or shall I just go through Reed Briggs, just a recent case? No, all right. Well, in the interest of time, I might just go through this one. It's not a particularly long case. I'll pop the citation in the chat now for people. So in this case, the deceased, Faye Briggs, made a will on the 19th of January 2010 and made a second will on the 19th of January 2016, and both of these were prepared by the public trustee. The only difference between the 2 wills was that the 2010 will made reference to monies owed to her by one of her 2 sons. So in this case, the public trustee had been appointed as the executor under both wills, but they renounced their appointment, so they didn't want to get involved. And so one of the sons, Shane, he sought to admit one of the wills to probate. The court actually made some comments. They were a little bit, the court, Justice Davis, was a little bit surprised that this was brought before him because it turns out there was sort of quite significant evidence to suggest that the later will that was done in 2016 wasn't valid, but that's okay, it happens. So Justice Davis firstly made reference to the presumption in Symes and Green that a duly executed will is prima facie proof of testamentary capacity. And in this case, both wills, the 2010 and the 2016 will, were duly executed. However, the evidence that rebutted this presumption was that on the death certificate, cause of death had been listed as dementia. So that shifted the onus. Now, ultimately, in this case, His Honour found that the deceased, Mrs. Briggs, didn't have capacity to execute the 2016 will, and instead the 2010 will was propounded. And in this case, because the public trustee had renounced its appointment, a grant of letters of administration with the will annexed was issued. So in this case, His Honour explains why Willmaker Fay didn't have capacity, and this is at paragraphs 25 to 31. So His Honour said, there is, in my view, no reason to doubt Fay's capacity to make the 2010 will. Shane, one of the sons propounding the wills, swore that Fay didn't show signs of memory loss or other cognitive shortcomings until about 2012. Until that time, she functioned well and could largely look after her own affairs. There is evidence, though, that by 2016, Fay had significantly declined. So there was actually a letter from a doctor, Dr. High, I think it's pronounced, from the Logan Hospital, that was prepared on the 28th of July, 2016. And in that letter, he wrote, "This letter is to document that the above patient, Fay Briggs, was found to have no capacity in relation to decision-making for personal healthcare decisions. This has been documented by the Logan Hospital geriatric team in her most recent admission notes, a copy of which can be obtained if required." Then again, Dr. Hines, on the 28th of February, 2017, wrote that this is to certify that Ms. Fay Briggs has Alzheimer's dementia and does not have the capacity to manage health, personal or financial affairs. So you've got two letters attesting to the fact that Fay no longer had capacity. There is evidence that Fay was confused around the time that the 2016 will was made. His Honour pointed out some key evidence. For example, Fay told Shane that she had made an appointment with the public trustee to remove Keith, the other brother, as her attorney. This was the appointment which ultimately led not to change her attorney documents, but to make the new will. And so this, the court said, showed some confusion around what was going on when instructing the public trustee. So there's other items that the court pointed to that really demonstrated that the 2016 will was prepared at a time when Fay didn't have capacity. So ultimately, the 2010 will was held to be valid, and that was admitted to probate. So have a look at that case. Very recent. Yeah, I think that came out. Oh, sorry, Jessica. The case is Briggs, BRIGGS, deceased, 2023 Queensland Supreme Court 226. So hopefully people can see that. I can put a list together and circulate it in the Moodle messages as well, so people have that list. Cool.
Question?
Yes.
If the case came to you, or you were working on that case, I was under the impression, and I've seen a few cases, that dementia can't be a cause of death. It might lead to other things, but it can't actually be a cause of death.
I agree with that too.
Look, I can't really comment on that except to say that regularly we do get death certificates noting dementia. Often it is in conjunction with another condition, but I have also just seen Alzheimer's disease as the sole cause of death. So I'm not sure. Yes. Sorry, Ian, I don't know if I can.
I sat in on a few coroner's cases and they didn't accept it. Was and the other was Parkinson's disease.
Yeah,
they didn't accept that as a cause of death either. It leads to something else. Like they can identify the dementia in the brain when they split it, but as far as cause of death, it's normally kidney failure or something else because they've forgotten to drink or they haven't eaten. Or Yeah,
Right.
well, that I thought that might have been a challenge for that one, an appeal or something, but
It
well,
wasn't. Justice Davis didn't raise it. But that I haven't had issues with that when applying previously. So I can't really comment, Ian. I'm
I
sorry.
feel like it would I feel like it would depend on like the facts of the matter and like, you know, what happened in the lead up to their death, and you know what I mean? If
Yeah.
you know, if but it's got to evaluate it all differently.
Yeah, absolutely. No, but very interesting. I mean, if it's something that's getting explored in, you know, coroner's jurisdiction, I'm sure it will probably have flow-on effects, you know, in the coming years if there's a sort of findings around what's appropriate to list as cause of death.
yeah, 'cause you don't find many of the succession cases are actually appealed, do they? Once they get through the Supreme Court, I suppose it gets too expensive. But
Yeah.
yeah.
Yeah. It's quite
Okay.
difficult.
I'll just ask another question. I hope it's not
Yes.
a silly question, but you know, wills go up for probate. Like, if it's just a mum and a dad with a very basic will, like it's not, you know, what happens with those sorts? Like, because, you know, I've had family members pass away, not, but I didn't go to that extent. Like, if it's just a basic sort of thing, we can sort of continue on.
Do you mean like the application for probate itself, or or getting the grant? So I mean, if it's just mum and dad, simple assets, but you need a grant of probate, if there's nothing on the death certificate that suggests a lack of capacity, so I should say there's the registrar sort of notes X amount of conditions, which I can find and circulate, that will give rise to a question of capacity. So if the cause of death is, and I'm generalizing, but heart attack, ordinarily that doesn't give rise to a question of capacity. Whereas if the cause of death is dementia, noting what Ian's just said, but if the cause of death is dementia, the registrar will sort of think, when did the person suffer from dementia? When was this will made? Do we need further evidence? Without getting into sort of the nitty-gritty stuff, when you actually prepare your application for a grant of probate, if there is an indication that the person may have suffered from an illness that impacted capacity, you actually swear to whether or not you believe, as the applicant, the person had capacity. So not all matters where there's a question around capacity will necessarily end up before a court. I think in this case, I think the judge was a little bit surprised that this was before him. And I should say it was heard on the papers. So no one appeared, just everything was filed with the court and the judge looked at it and made this decision. But sometimes people are reluctant to make that call. So you've got these two wills, 2016, 2010. Faye was fine, 2010, no inkling of dementia, she was fine. 2016, she'd been diagnosed, you know, suffering. She was in quite a poor state. I probably would have tried to propound the 2010 will and said, look, for these reasons, we don't think this will is valid. But some people prefer for the court to exercise its jurisdiction and make a determination. So not all wills have to go before a judge in this manner. If there is a question of capacity, often it can be dealt with in your supporting affidavit material. But if there really is a question and there's no clear answer, that's when you may need to ask for a court to look at the matter. Yeah, does that sort of answer your question?
Sorry, it's possibly a silly question, but I just
no.
It's all a bit new for me, so I was
no.
Yeah.
And look, 9 times out of 10, an application for a grant of probate is a fairly standard, straightforward matter. It's just, you know, I guess in this forum we always look at what goes wrong and what we can learn from it and all of that. So that's why it's sort of highlighted, I think, Emma. Yeah. All right, guys, we've got 10 minutes. Oh no, we finished. Oh no, one more. All right, having regard to the test in Banks and Goodfellow, so your four limbs, what are some steps that you might take or questions that you might ask when determining if a will maker has capacity? So if you are a solicitor and you maybe weren't 100% sure, or you just wanted to make sure that you were taking very thorough file notes, what are some questions that you might ask?
I would ask them if they understand what they're doing, and I would try to find out if they were delusional in any way as well.
Yep, and what sort of questions would you ask to find that out?
Well, it's interesting trying to find out if someone's delusional, isn't it? Because they might give a response that indicates that they know what's going on, but still be delusional. So I'm not sure.
So look, general rule, asking open-ended questions, asking them why they're here, what they're doing, asking the person to explain if they, can explain their family situation, all those sorts of things. And look, to a degree, you can ask someone about their health, ask them if they've got any, particular stresses. You will be guided by your client and the appointment and what's presented to you. But you can delve deep, open-ended questions, asking clients to explain concepts back to you. That's a really good one. And quite often you can tell if someone...
Sorry, Arabella, we lost you there for a minute.
Oh, okay. Am I back? Coming loud and clear, hopefully. I was just saying, asking open-ended questions, asking people to explain concepts back to you, and also just looking at the instructions that they're providing once you know a bit more about their background. Sorry, Reese, I think you've got your hand up.
I think Ella had it up before me.
Oh, sorry, Ella.
Oh, that's okay. I was just going to say, what we do before we have a client sign a will, we obviously have the solicitor in the room and then the client, and then we also have the second witness. And we have a specific precedent that we use, and it has 5 questions that we ask the client before they're allowed to sign the will. And the questions are, what is this document? Have you read it? Do you understand it? Do you believe it reflects your wishes? And are you ready to sign this as your will? And if we're satisfied with their answers, then we believe that, okay, they can sign their will, we're happy for them to execute this document. Now, obviously, that's after you've taken instructions, but I just think I didn't used to do it at my old firm, but I think it's a really good practice to ensure that people are understanding what they're signing.
Great. No, that's a great example. Reese?
Yeah, the firm I used to work in, and I'm just curious what your thoughts are, Arabella. Apart from open-ended questions, if you start to get a bit of an iffy feeling, we used to ask not me, but the solicitor would ask random closed-ended questions like who's the current Prime Minister, what primary school did you go to?
Yeah.
Things like that.
Yeah. And look, that's another sort of good tool in the toolkit. Just sort of asking questions that allows the client to sort of orient themselves with what they're doing and now. The other thing to sometimes just be aware of, and it can be very difficult, is sometimes clients will learn an answer. They'll sort of provide you with answers that they think you want to hear or that they've been told to say. And it can sometimes not be very obvious that this is happening. But you eventually, if you ask different questions and you're getting sort of the same answer or a variation of it, you can sometimes pick these things up. So throwing in some random questions about, current affairs, or what did you do yesterday? What are you doing after this appointment? can really shatter that and sort of highlight that perhaps this person doesn't really know what they're doing. So yeah, Reese, good example of things to do. Yep. Julie?
I was just going to confirm what you were just saying about a lot of the time when you do psychological assessments, they ask you the same question 5 different ways to try and see if there's some consistency in your answer.
Right.
So it's about thinking, how can I ask that question maybe 2 or 3 ways to test whether the answer is the same and they're actually understanding what I'm asking?
Mm-hmm. Yeah, no, that's a very good point. Yeah, absolutely.
Can you go one step further if that's the case, rather than asking a whole range of questions and putting them to the test, getting a doctor's report stating that they have mental capacity at the time of making the will, and then file that with a will?
So, look, absolutely. And solicitors will do that, but I guess it's not always obvious, when your client comes in that capacity is an issue. And B, it can sometimes be abrupt to simply say, I don't think you have capacity, go and get a report. Because again, testamentary capacity is different to legal and medical capacity. So, in the Roe case, we saw that. Or no, it wasn't Roche, sorry. In Roche, we saw that. So a medical report, very useful. And absolutely, I will ask clients to get that. But it's still really important to make these inquiries relevant to your Banks and Goodfellow test. Julie?
Yeah, I just want to say, when you were bringing up the case that I was talking about, they actually had 2 experts give a medical report on the testator, but they disagreed naturally, because one was with the defendants and one was with the complainant. So the plaintiff, I should say, or the applicant. So they actually disagreed. So they actually had to work out other ways of actually, and what weight they were going to give each of those experts. So that can still happen as well.
Yeah. Great. All right. Well, look, I think today's been really great. Does anyone have any final questions or closing comments for weeks 1 and 2? We've covered a lot of ground. Oh, sorry, Bill. Yes?
Been most enjoyable.
Yes, I was going to say we've covered a lot of ground, and we've had some really, really great discussions, which is wonderful. It's always really great when people are engaged and we can have these discussions, because I think that's how you learn. So on that note, at 7:58, I'll call this workshop to a close. If you do have any questions, feel free to email me. I'll come back with the list of cases and I will fix up the review questions and confirm answers. But otherwise, I'll see you all next week. Have a great week.
Thanks, Arabella.
Thanks, everyone.
See you next week.
Bye.